Yes, Mr. Quintavalli.
And Lords, I was going to take the court to some authorities on what the protection of health means. As promised, I've had a look at authorities on Article 6, and if it hasn't been sent up already, there will be a case called Straume and Latvia, which is a case which concerns an infringement of the right to open justice. Someone was objecting to having hearing held in private when they didn't want it. I don't propose to go into this in any detail, but it's there for the court. I think paragraphs 124 and 125 of that case, when it comes through, will be useful just to see that that is a recognised right under Article 6. The other case which is being sent up is the case of the Strasbourg decision, admissibility decision, in the case of Guard and the United Kingdom. And that's a useful case because it shows a complaint was made by the parents on the basis that their Article 8 and Article 6 rights were infringed. And it was a question of concern to the court, obviously, of what sort of rights they held in this sort of process. And we say that that case shows that there's a recognition by the court that their parental responsibilities are engaged. And the Article 6 complaint wasn't considered because the court held that the same arguments arose under the Article 8 complaint. But if I could just indicate paragraphs, when the case does come through, paragraphs 56, which explains the objections made under Article 6 and 8, the complaints made under Article 6 and 8, and paragraphs 104 and 110, which then the court has something to say about those rights. But
so 104 and
110.
110, thank you.
Just to show, to make good our submission that parents' rights are engaged in these sort of proceedings and that they are being determined for the purposes of Article 6 of the Convention. Lords, if I could return then to where we were at, and I wanted to look at a case called Movement, Raelian and Switzerland, and it's...
Well, but the issues were completely different. I'm just looking at it, and I see the Article 6 issue concerned the domestic courts. Well, the complaint was under Article 6 that the domestic court hadn't heard witness evidence on the critical point. And under Article 8, the complaint was that the domestic courts had taken their decisions in the best interests of the child, and that was a disproportionate interference with the complainant's parental rights. So, I mean, they weren't the same issues that we're concerned with.
They weren't the same issues, but what the case, we say what it shows is that their rights in some context, and this was the context in which the application was made and the complaint was made. It wasn't made in the terms that we've presented it, but nonetheless there's been a recognition that their rights, at least in those respects, are interfered with. And obviously, there was justification for it, and the parents didn't succeed, but nonetheless, the engagement threshold was met, at least in the respect in which that application was made. It doesn't take the point any further, and that's all I was able to find in the time I had. But I stand by the submission that was made before, and the point on Article 6, I think really there it is more straightforward, and that I hope is a case which answers what I believe was the concern of the court about whether there was an authority which dealt with that issue directly.
Well, I don't think this case does. The concern was that we all know that Article 6 requires a public hearing, but your argument in the present case is Article 6 also requires, in principle, freedom to publicise what took place in the court proceedings. And I was wondering if there was any authority to the effect that Article 6 went that far.
Well, that I wasn't able to find, but just the...
And it may not be necessary because you rely on Article 10, and Article 10 protects your freedom of expression.
I do. I also rely on the common law open justice imperative. And the case of Scott and Scott is important because there were two aspects to that case. One was whether the courts had jurisdiction to hold the hearings in private. But the second aspect of the case is, did they have jurisdiction then to prohibit a reporting of what happened in those cases? And on both questions, the answer was no, there wasn't. And so it may be that Article 6 I don't need to rely on, but nonetheless, I do make those submissions. My lords, the Mouvement Raelian case is at page 3996, is the paragraph I want to start looking at. And this case concerned an organisation that was promoting all sorts of things which the Swiss authorities weren't very happy with. We see there in paragraph 16 that they were promoting human cloning, something called geneocracy, and central meditation. And they also had an organisation called CloneAid, right at the bottom of the page, paragraph 17, and it says that they were offering services in the area of cloning, and something about the notion of eugenics was also being promoted, which was objected to. On paragraph 19, on page 3997, we then see that that the criminal complaints had been filed against the movement alleging existence of sexual practices that were intended to systematically corrupt young teenagers. And so it was on that basis that the speech, they wanted to put posters up publicising their activity, but that the interference on the grounds of health was felt to be justified, amongst other grounds. There were several grounds were raised, but it was found that these were all legitimate aims for the restriction of speech. And this is just one case. There aren't so many authorities that are helpful to explain what that particular ground means. But what we say that this shows is that where the speech at issue is directly concerned with encouraging or promoting practices which are detrimental to health, then that certainly satisfies the grounds for legitimate derogation under Article 10.2. And in the present case, we say that obviously isn't the case, because any effect on the hospitals or on the health service as a whole is indirect. It's not what the speech is concerned with, and it's not what the speech is directly bringing about. And that's why we submit that the Court of Appeal was correct to say that when one's dealing with concerns which are removed from the object of the speech itself, that doesn't fall within the legitimate aims ground. It becomes a generic concern, which...
So where does it say that in this decision?
What are you relying on in the court's assessment?
I'm sorry, my lord?
So what are you relying on in the court's assessment to support your submission? In this case,
I mean, this just seems to be an example of a particular type of case where the protection of morals may be invoked.
Yes.
It's not saying that category is confined to this sort of case. It just seems to be silent.
The Court of Appeals, what the Court of Appeals said is that there's no authority in Strasbourg which shows that the generic concerns have satisfied a legitimate aim requirement. Now, there aren't many cases on point. There's another case on tobacco advertising where that was also held to be legitimate restriction to prohibit it. There's one other case in the bundle that we've got, which is called the case of Mamer in France, and that's at 4986. That really is looking at the matter from the other point of view, because that's.
So, sorry, just before we leave
Yes.
this authority, was there any particular passage you wanted to refer to before we leave this?
Well, paragraph 54 is the one which talks about the legitimate aims, and it's on page 4011. And it just says, the legitimate aims pursued by the restriction, the government indicated, as the legitimate aims, the government indicated that it sought to prevent crime, to protect health or morals, and to protect the rights of others. Then we see in the following paragraph that this wasn't, the applicant association not denied that those legitimate aims, and so it was accepted by the Grand Chamber that these were legitimate aims. It's not.
Since there wasn't a dispute about the question of legitimate aims, it's unlikely to be a leading authority about the limits of that concept.
No, it's not a leading authority, but the court isn't going to, even if there isn't a dispute, Grand Chamber is not going to say, well, it is a legitimate aim when it manifestly wasn't. But the point the Court of Appeal was making is that no authority has been cited which shows that the generic concerns can constitute legitimate aims. And this is just an example. There's no that, but where they certainly would constitute a legitimate aim, we say. And it's a legitimate point that the Court of Appeal's making. It's not for, if free speech is the default, it's not that we need to come up with Strasbourg authorities which show that there are no grounds for restricting speech on this basis. It's for the people who want to restrict the speech who are going to have to pick up the Strasbourg authorities, and there's simply none have been put before the court. And this case I refer to because it's in the bundle, and it does deal with this issue. The other case is the case of Mamer against France, and that's, I'd like to look at paragraph 20 on 4998. And I should say the case concerned conviction against someone who had defamed a public servant in breach of Article 10. And the criticism which had given rise to the conviction was the suggestion that the civil servant had knowingly minimized the risks to France of radiation from the Chernobyl accident. And what the court found was that the speech that concerned public health was subject to a high level of protection. But that means that where people were raising concerns about an authority's, in this case, where they were raising concerns about speech by the civil servant, then because it was so important to protect health, then this was going to be given broad protection. And this is what it says at paragraph 20. That being so, the court points out, first of all, that the instant case is one where Article 10 requires a high level of protection of the right to freedom of expression. Two reasons. The first is that the applicant's remarks concerned issues of general concern, protection of the environment and public health, and how the French authorities dealt with those issues in the context of the Chernobyl disaster. It also, but I don't need, we'll be looking at the case of Bussayuk and Moldova. But at paragraph 27 of this case, 5001, we look again at the issue of whether there's protection to civil servants, or to what extent there is. And I'll be turning to that principle. I don't think I need to look at this case. I think it's be more helpful to look at the Bussayuk case in shortly. But the other cases which the trusts rely upon, they say that the cases of Bloomberg and in Ries show that these public policy concerns are both the legitimate aims and the proportionality, and would properly have been weighed in the case. But we say that on closer analysis, the story is rather different. The identified public interest in Bloomberg concerns the preservation of information obtained in confidence. And this is precisely a ground for legitimate derogation under Article 10.2, namely for preventing the disclosure of information received in confidence. So in that case, ZXC could argue that a restriction on press freedom in his case was justified under Article 10.2, since it involved the disclosure of information received in confidence. And for that reason, it's neither surprising nor controversial that the public interest should have had a central place in the balancing exercise in Bloomberg, since it was the very interest which justified the claim. They coincided. And if we look then at paragraph 81 of the case, it's 3529, we see another fact which is important, and that's that the existence of the policy itself led to the developing of the general rule that someone being investigated for a criminal offence had the legitimate expectation of
Where are you reading from?
From paragraph 81 on page 3529.
Yeah, it's the first point there, is it? Yes.
So because of the adoption of the public policy, it was precisely that public policy being adopted by the authorities and recognised by the courts, and the paragraph explains everything that happened. But it was precisely because of that the reasonable expectation of privacy arose. If a different policy had been adopted, then there wouldn't have been the reasonable expectation of privacy. So some say they coincide. And similarly, in Ries, the freedom of the press to report on open court trials was the very right in question in that case. So again, it's the same policy. So it's not surprising that, since it coincides precisely with the right, that it could be invoked and given weight to. But the difference in this case is that there's no coincidence between the policy considerations and the right at issue. The clinicians want privacy because they don't want to be vilified, and there's a separate public policy consideration, including to prevent disorder, crime, and protecting people's health, which are just not connected directly with that privacy right. And so we say the latter not relevant to assessing the former. And it was for this reason that the Court of Appeal rightly held that these generic considerations are not relevant legitimate aims under Article 10.2 for restricting Article 10 rights. Perhaps this, as we saw, the President said that he wasn't, in fact, required to establish that the legitimate aims had been established as a requirement, because this was a horizontal, not a vertical case, and he accepted Mr. Miller's argument on that point. But we say that was wrong, and that the Ries analysis did require, on the Article 10 side, the legitimate aim considerations to be established and weighed. And I believe, I may have misunderstood, but I believe this was the point my Lord Hodge made yesterday about the independent assessment of each right. It's not simply we're going to weigh up Article 10 against Article 8 is we've got to consider Article 10 on its own merits on one side and Article 8 on its own merits on the other. And when we consider Article 10, we have to look at the legitimate aims. And so the exercise the President engaged in, saying, well, we don't have to find that any legitimate aims are established under Article 10.2, was incorrect. That needed to be done, and that wasn't done. And when the Court of Appeal turned its own hand to it instead and did the proper balancing exercise, it came to very different conclusions. It found that these generic concerns were not made out, and they didn't properly satisfy legitimate aims requirement. And I want to look at a domestic authority, or two domestic authorities which also deal with this. And it's a case called H, a healthcare worker and Associated Newspapers Limited, and that's at page 2438. And it's citing Venables also, so two Court of Appeal authorities in one. But the paragraph 41, Court of Appeal says, in Venables, the President was at pains to reject the submission that the court had jurisdiction to grant an injunction to prevent an interference with one of the fundamental human rights where no breach of a duty owed under our private law was made out. We would view with concern any attempt to invoke the power of the court to grant an injunction restraining freedom of expression merely on the ground that release of the information would give rise to administrative problems and a drain on resources. Such consequences are the price which has to be paid from time to time for freedom of expression in a democratic society. And that addresses at least some of the concerns we say that the trust raised. Part of the concerns relate to these administrative problems. And they're not, again, point we made at the outset, it could have been the case that the child was being treated in a private hospital. It's not that the state's involved, therefore we have to be concerned about the health of the whole citizenry. The issue is, when it boils down to it, these are private concerns of the hospital, maybe very legitimate concerns that they have. But they're not public policy concerns in the same way as those that were identified in Ries and Bloomberg are. Three other cases were mentioned by the trusts. They're the cases of Greencorns, Ashworth, and the Midra Meat case. And my Lords have my submission in the written case on those cases, and I don't propose to say anything much more. Greencorns was an application for an interim injunction. It's the first point to note. It wasn't an application for a final injunction. So a different test would have applied as to whether it should have been made or not, and maybe some of the important concerns there as to whether an organisation can bring an injunction on behalf of convention interests of private individuals, the ones which could have been subject to proper reasoning had the matter come before the courts for a final hearing on this issue. But our position in the courts below was simply on that point, that it was wrongly decided, and that for the same reasons that Lord Reid pointed out, it was the appeal to Ashworth isn't supported by the reasoning in Ashworth, because Ashworth had its own rights, quite independently of the patients, to ensuring the confidentiality of the patient records. The Midrana Meat case is, first instance, family division decision, which mirrors the issues underlying the cases under appeal here. And so we say it suffers from the same vices in many respects, and it doesn't help us in determining whether...
And what's the page number for that?
I'm going to look at what the Court of Appeal had to say at page 3084. That's when it was known as Re-N. I shall dig up the page number for the first instance decision is 2657. I wanted just to look at 2660 of that case, because a question arose yesterday as to whether it was an application to discharge an injunction or to make a new one. And paragraphs 1 and 2 explain what had been going on. And it was an application for a reporting restriction order in circumstances where an order had been made already, but was one which the judge had indicated was coming to an end at the end of the proceedings. So it was essentially wasn't a discharge application as such. It was an application for an interim order, as it were, to become a final order, perhaps. That would be a way of categorizing it. And I would like to, it's an appropriate moment to take the court to the question of how long these orders should last, because that was an issue which the Court of Appeal did look at in this case, albeit in the context of an unsuccessful permission decision. But the Court of Appeal judgment is in Re-N, and the passages I wanted to look at were on 3084 and wanted to look at paragraphs 100, 103 and 104. So at 100, we see that the judge found that a number of allegations made by the father at trial in relation to Midra's care were untrue. In additional evidence in support of the making of an RRO came from Dr. G, who listed some 6 specific allegations that Midra's father had made against the treating clinicians or the hospital team more generally, which were said to be on the judge's findings were untrue, and which Dr. G said were hurtful and, if repeated publicly, would be likely to cause the individual employees great distress and place them under further significant psychological pressure over and above that which has been experienced on the ward by those treating Midra for the past 4 months. And then at 103, the Court of Appeal observes that parents no doubt say and do all manner of things in the tragic and difficult circumstances in which they find themselves in such cases. And then at 104, there's the question of the time limit in that case, because the trust had proposed a 28-day limit after the ventilator had been disconnected, within which the reporting restrictions should still exist. And the Court of Appeal says, in any event, the Respondent Trust has taken the view that it is likely that the potential for any adverse publicity will have significantly diminished once the ventilator has been disconnected and a short time has passed. They therefore would agree to a time limit being placed upon the RRO so that it would expire, subject to any further application, 28 days after the date upon which the ventilator is disconnected. And leave the Court of Appeal in this case made reference to that time limit as well. So that's an example of a case, and where there were serious accusations made by father, and accusations that were so serious that it was considered necessary to protect 370 clinicians. But nonetheless, the trust in that case recognised that that after a cooling off period, that it was unlikely that there was going to be any more risk to the clinicians.
Was there any discussion before the President of a cooling off period and a time limit?
In
the current case?
So, when the case came before the President, many years had already passed since the hearings had been heard originally. There was 3 years in the
3 years in one case and 2 in the other, I think.
Yes. So, when I address at the end of my submissions the sort of safeguards or the sort of approach that the court should adopt, if there is to be a cooling off period, and it may be a sensible approach that the court thinks gives adequate weight to the rights involved, I would be suggesting that 28 days is the sort of period that would be suitable, not 3 years or 6 years or the sort of times that we're talking about in this case.
I understand that. My question, however, was there a discussion of a limited period needed to protect the alleged Article 8 right before the President?
The President, there wasn't. No. The President evidently felt that it was the situation necessitated these restrictions remaining in place.
Well, he was dealing with, obviously, what was apparently a permanent injunction,
yes,
or injunction without limit of time, so that the matter simply wasn't addressed whether there should be a time-limited injunction or there should have been a time-limited injunction.
It wasn't addressed, but obviously 3 years wasn't enough as a cooling off period as far as the President was concerned in that case.
But my point is the issue wasn't addressed. The whole idea of a cooling off period wasn't discussed.
Not as a matter of principle in that case.
That's what I wanted to know. Thank you.
So
I think I get the impression it was really all or nothing. Either the injunction stays or it goes.
Yeah.
Before the President. Yeah.
Well, the position of the trusts before the President, and it may be that they were mindful of the sort of procedure which would usually be adopted, but the trusts had proposed 2 options. Either the injunctions remained in place, or they were discharged and then immediately replaced with new injunctions. But as it were, they were kept in place.
I assume that you suggest that any reporting restriction order has very wide liberty to apply for the benefit of parents or for anybody else, for that matter. If a reporting restriction order is set aside, and could there be potential for an application liberty to apply to reinstate it?
Yes, and the preferred approach we would submit is that is precisely that if there is to be a cooling off period, that the presumption is that the order will expire at the end of that period, but that people who want it to continue would be able to turn up and adduce the necessary evidence as to why it should continue. My Lords, I'd like to look quickly at 2 Strasbourg authorities just to conclude this generic evidence submissions. The first is Haastrup and Moldova, which we looked at yesterday, and it's at page 3613, but I'll be taking the court to certain passages. It was cited by the appellants yesterday in support of a supposedly well-established and consistent principle in Strasbourg Article 10 case law favouring the protection of civil servants, including those at public hospitals. That's how the trust has essentially put this case. But We say that, in fact, looked at in a little bit more detail, the case simply doesn't support this broad claim. Bussillot concerned a journalist who had made, as we saw, published an article alleging all sorts of nefarious goings-on at a public airport, which included nepotism, incompetence, and corruption. 6 employees sued for defamation, and the domestic courts found defamation in respect of 5 of them and awarded damages. So then the claim came before Strasbourg and saying that there'd been an interference with the Article 10 rights in this case. And before looking at the passage cited by the appellants in support of their proposition, it would be useful to look at paragraphs 57 and 58, which are found on page 3627, to see what we say the true principles which the court found to be at play. 57 says, the most careful scrutiny on the part of the court is called for when the measures taken or sanctions imposed by the national authority are capable of discouraging the participation of the press in debates over matters of legitimate public concern. And paragraph 58 has well-known passage about the right of freedom of expression applicable not only to information or ideas that are favourably received, but then we have a sentence at the end of it saying, in addition, journalistic freedom also covers possible recourse to a degree of exaggeration or even provocation. So those were the principles to be applied, and then we then see what the Moldovan government had to say about that at page 3628, paragraph 63. And so there we see that the government contended that the complainants in question were civil servants, and therefore, unlike politicians, they should enjoy a higher level of protection from undue criticism and scrutiny. And then, straight after that, we come to the passage relied on by the appellants, which is the beginning of the European Court's response to the Moldovan government's claim. And so we see that the necessity that the court has found to protect public servants. But it's the next part which is the important one, which isn't cited by the appellants. And that's this. However, the court considers that the present case should be distinguished from the Janowski and Nikula cases for the following reasons. First, the complainants in issue were neither law enforcement officers nor prosecutors. It would go too far to extend the Janowski principle to all persons who are employed by the state or by state-owned companies. Second, the applicant's remarks form part of an open and ongoing discussion of matters of public interest. Moreover, in contrast to the statements made by the applicant as a private individual in the case of Janowski, the impugned article in the present case was written by the applicant in his capacity as a journalist and gave rise to issues of freedom of the press. And I'm conscious that I don't want to be falling into the same impropriety that I'm accusing the trust of standing up for interests I've no right to stand up for. But the press did want to intervene in this case, and it's not just the parents' rights which have been interfered with. So it's right that even though the parents are individuals, nonetheless, the press also do want to comment on these cases and to be able to name people involved. So hospital staff are not law enforcement officers or prosecutors for whom special protection under Article 8 may be appropriate. And just in this case, as in Bussillot, the impacted speech concerns matters of public importance. So the court then concludes at paragraph 65 that the approach employed by the court in the Janowski case is not applicable to the present case. And two of the, I won't take the court then to the findings, but with respect to two of the defamation claims, the court found that they were breaches of Article 10 because the claims involved, I can give the references, it's paragraph 74 and 75 at page 3630, and then 84 and 85 at pages 3631 and 3632. that the claims concerned value judgments that were being made by the journalist, which people should be entitled freely to express. So we say that far from helping the appellant's case, Busse demonstrates that Strasbourg does not recognise a special status for clinicians and thus does not attribute them heightened Article 8 protection. And further, that people in the press in particular should be free to express value judgments about the public employees, where there's any suspicion of impropriety, and that Article 10 protects this right, even subject to a degree of exaggeration and provocation. And we say that the Court of Appeal was correct to allow, to hold that generic concerns would breach the EULA principle, because there's simply no authority for those concerns constituting legitimate aims.
Do we have Janikowski in the bundle or not?
I don't believe we...
Not to worry, it's okay.
Don't believe we do. And in support of that, the final case I wanted to look at was the Grand Chamber decision in Chassagne in France, which is at 3637. And this case concerned French law, which obliged small landowners to join hunting associations and to make their land available for hunting. And the claim was brought under Articles 9 and 11 by landowners who opposed hunting and who did not want to join the hunting associations or make their land available for hunting. And the French state relied on the promotion of a right to hunt, encouraging people to participate in hunting as legitimizing an Article 10.2 derogation under the rights of others head. And the Grand Chamber had this to say concerning the rights of others, and it's paragraph 113 at page 3709 that I'd like to take your lordships to, and it's about halfway down the first paragraph of 113. The balancing of individual interests that may well be contradictory is a difficult matter, and the contracting states must have a broad margin of appreciation in this respect, since the national authorities are in principle better placed than the European Court to assess whether or not there is a pressing social need capable of justifying interference with one of the rights guaranteed by the Convention. And then this is the important sentence. It is a different matter where restrictions are imposed on a right or freedom guaranteed by the Convention in order to protect rights or freedoms not as such enunciated therein. In such a case, only indisputable imperatives can justify interferences with enjoyment of a convention right. So if you are going to rely on policy or administrative concerns which are not themselves rights enunciated in the convention, then the Grand Chamber in Chassagne says that you need to establish an indisputable imperative before that legitimizes the interference. And we say that the evidence falls far short of establishing that in this case. I'd like my lords to turn to the risk direction. The trusts found the risk direction to be problematic for three reasons. First, they say that it imposes a burden of proof on the trusts to show a risk of harm. Two, that it imposes a standard requiring substantial or real risk of harm. And three, in so doing, it improperly imports into the balancing exercise the language of quite time-less injunctions. Taking this quite quickly, being conscious of time, we say that the burden of proof and the standard, in fact, is supported by authority, contrary to the trust claim. The first point is we refer to Scott and Scott, which makes it clear, but it's a point then taken up by later authorities too. It's not a controversial point, but it makes it clear that the burden is on a party wanting to displace the open justice principle. And one of the passages we like to take the court to is at 3284, where the Lord Chancellor Viscount Haldane says that yes, right at the top, the burden lies on those seeking to displace its application in a particular case, to make out that the ordinary rule is be superseded. So as far as the burden is concerned, people who, and this is an important aspect about this case, because it's not simply, at least in a certain respect, with regards to what was going on in the trials or what was happening, reporting of witnesses. It wasn't just about an Article 10 versus Article 8 balance, that there's a desire, or to displace the open justice principle, and therefore the burden is on the trust to show that. And that's quite independent of any Article 10 considerations. As regards the standard of proof, we rely on the Court of Appeal decision in Clifford and Millicom, which can be found at 2219. It also considers the burden and the standard. Now that case, that decision was handed down very shortly before the Abbasi Haastrup decision was handed down, and it wasn't obvious. But after the hearing in Abbasi and Haastrup, there's a lot which is potentially useful there, but the case, at least with respect to its consideration of some of the Article 8 issues, relies on the President's judgment, which obviously we say is not correct. The passages that I would like to take the case concerned, I should say, it's an employment dispute where Mr. Clifford claimed that he'd been dismissed for making whistleblowing allegations in relation to certain activities of certain employees in a foreign country, which he'd been employed by the company to investigate. And the company applied for a restricted reporting order under Rule 50 of the Employment Tribunal Rules of Procedure to prevent the naming of the staff or the subsidiary in the country concerned, because they said that this would place that staff at risk of breaches of their convention rights under Articles 2, 3, 5, and 8. And by the time the claim came to the Court of Appeal, only Article 8 was still left. As far as the other rights were concerned, they were no longer, it was established that there wasn't the risk hadn't been, the thresholds hadn't been met. Part of the appeal also concerned whether there was a separate and distinct obligation under the common law towards witnesses and third parties to protect the right to life and security of a person and to ensure that proceedings do not risk life and limb, which are obviously permitted derogations to the open justice principle. And the Court of Appeal affirmed that there was such an obligation, but that in such cases, and I'm looking at paragraph 36 at page 2230, that in such cases, the court will look for evidence of a real and immediate risk of harm. And we'll see that ties in when we look at the risk directions. When we look further at the risk directions, this ties in with other case law. The evidence which was presented before the court is described in paragraphs 55 to 59, which starts at 2235.
I mean, again, there's a danger of looking at authorities in a different context. In this context, if we're concerned with convention rights, then it's Article 2, and it would only be triggered by an imminent risk to life, the positive obligation. So it's not, I think, to be taken as laying down, or at least it shouldn't probably be taken as laying down a general rule that
I'll take the court to what it says about Article 8.
Derogations from open justice are only justifiable if there's an imminent risk or an imminent risk of harm. That probably reflects the particular Article 2 context.
I wanted to outline the evidence because it was relevant then to the Article 8 considerations. But the passages I've taken the court to, I just note, refer to the risk of people being abducted, beaten, killed, arrested, detained, prosecuted on trumped-up charges, arbitrary arrest, detention and extortion in a country where the rule of law did not operate and where corruption was systemic. But it's at paragraph 62 on page 2237 where the question of the Article 8 thresholds is dealt with. And we see there's questions. One of the questions which the courts were looking at below, or the tribunals were looking at, was whether this was speculative or objective concerns, and whether the correct test had been applied in that respect. But halfway through that paragraph, we see that counsel for Millicom points out the applicant does not need to make the court or tribunal sure that the consequences at issue would happen, or even that this is probable. What must be proved is a real possibility of significant harm, a possibility that cannot be ignored having regard to the nature and gravity of the harm. And I mention that because in the next paragraph, at 63, Lord Justice Warby endorses this approach and found that since there was evidence of a risk, it fell to be assessed, and so the case was remitted back.
How does this relate to this case? Because all the risks have been set out by the President in paragraph 30 of his judgment, and there's been no challenge to them. And so whatever the test is, what difference does it make? Those risks have been established.
The question is the threshold. I mean, that a risk exists is not disputed by anyone, but how likely is that risk to materialise is the important question.
Was this focused on before the President?
Try, my Lord, to recall.
Because what is striking is that the President records in paragraph 30 a catalogue of risk and then says they weren't challenged.
If someone says there's a risk that this will happen, it's not possible to say, well, there's no risk at all that won't happen. And I think this was the problem or the position that the parents found themselves before the President.
Was it suggested that it was speculative and remote and not imminent or not real? Or, I mean, was there any qualification put on at any stage before the President to those risks?
By the time the case obviously got to the Court of Appeal, that was a position which had been adopted. I can't recall how the case was put before the President, but one of the issues which my learned friend makes, and in normal situations, the principle would also be correct, and it's that the findings of a trial judge are given deference by the courts for very good reasons. What we say in response to that is that the jurisdiction that the President himself acknowledged that he was exercising was a reviewed jurisdiction. because the injunctions had already been made. And we say all the evidence that was before the President was then before the Court of Appeal. He was in just as good a position to assess that evidence. And for that reason, there's no reason in a situation like this where the court should automatically give deference to the decision of a judge in the President's position, because he wasn't effectively the trial judge. He wasn't the one who'd assess whether the injunctions, when they were originally made, satisfied the thresholds which should have been before. The point of the thresholds is important because, again, it's impossible to deny that there's a risk, because of course there is a risk. But how serious is that risk? And that's the question that the court, whether it's making the injunctions at the outset or whether it's reviewing them as the President did or the Court of Appeal did subsequently, has to itself assess quite independently of what the parties might say about it, because it's got an obligation not to act incompatibly with the convention rights under Article under Section 6.1. I mean, whatever the parties' views on the risks is not going to change the reality of the situation as to whether Article 8 is engaged or not, or whether the right thresholds be met.
Well, I'm a bit concerned about the court being asked, or indeed the court doing this, laying down legal thresholds as general rules. I mean, what we know is that there has to be a balancing of the interests under Article 8 and Article 10 when they're competing, or it may be 8.1 and 8.2, or 10.1 and 10.2. So you have to consider the degree of risk of harm and the gravity of the harm if the risk eventuates, and balance that against the competing interests. But I wonder if one can really lay down more fixed rules than that. In Rabone is another Article 2 case, and there are thresholds in the context of Article 2 and also in the context of extradition cases, which was an Article 3, which is what the Court of Appeal referred to. But at the moment, I'm inclined to think that those rules that apply in those particular contexts don't carry over into the balancing exercise that we're concerned with.
This court in the Wolverhampton case, which had to consider a different balance because there were the rights of the travellers and the rights of the landowners. But it did set down rules, and if we turn to paragraph 218, which is 4442, we can see, and this is in the we can see this is in the context of the safeguards which are needed, and we see that there the threshold is there must be a strong probability that a tort or breach of planning control or other aspect of public law is to be committed, and that this case will cause real harm. Further, the threat must be real and imminent, and that's a safeguard of people's rights. So,
in the background to that is, as appears from the second sentence, we had previously said that there had to be a compelling justification for the order, and that's because the newcomer injunction is a form of, it's analogous to legislation in that the court is issuing a sort of bylaw that might apply, for example, to every petrol station in the UK or every area of open ground in a county, in a situation where there are alternative safeguards available. For example, local authorities can make bylaws. And so we've said that there has to be a strong justification for the court to make an order of that special kind. And this paragraph then explains the sort of evidence that's required to justify it.
So in the present case, we would say, making allowances for the different balance which is being conducted, but recognising that rights have been impacted, that a similar situation exists as well, because there are all manner of provisions in the law which protect privacy rights, and these are not ones which appear to have been considered at the time the injunctions were originally made as to whether they were adequate to provide the sort of protection that the injunctions instead seek to provide. And that's one of the safeguards, as my Lord Reed has just pointed out, the court had to consider in the Wolverhampton case, but it's also one of the safeguards which would have to be considered in this case. So
what safeguard is there available that would protect people from harassment in these circumstances? It's practical and realistic.
Well, we say depending on what form it took, but there's a statutory tort of protection from harassment. This is what the Parliament's decided how people should be protected from harassment. We have all sorts of other laws on malicious communications, on Public Order Act laws, defamation law if people's reputation is being unfairly attacked. We have the Moppy tort if private information is being misused. There are all sorts of other laws, and there hasn't been a consideration as to whether those are adequate or not. So we say the situation is, in fact, making allowances for the differences is similar to Wolverhampton. It's not, obviously an injunction is not creating a law as such or anything that approximates a bylaw, but in the same way as it's interfering with rights over people with respect to a particular bit of land. This is interfering with people's rights in a very broad way, and therefore it is appropriate that there should be thresholds. And this goes to again, if it was simply a matter of balancing Article 10 against Article 8, and there's an obligation on the court to do that, it becomes conceptually a bit more difficult to see how the threshold fits in. But if Article 10 has to be considered on its own, and whether the justifications have to be made out, then it's quite appropriate that these thresholds are considered. And the cases, I don't think I'm going to have time to go into them, but I can mention them and give the paragraph numbers. But the three authorities that we wanted to rely on, which...
Just before you get to those, can I just raise a conceptual point? I mean, when one's talking about Article 2 and Article 3, it might be said it makes more sense to talk about thresholds and being comparatively high, precisely because you don't get into a balancing exercise in relation to, or any possibility of justification for a breach of those. But when you're dealing with Article 8 or indeed Article 10, the very fact that there is the possibility of objective justification for an interference might be taken to suggest that actually either there isn't a threshold or it's pitched at a very much lower level in terms of engagement of the article, but then a lot of the work is then done in the balancing stage later on.
So that line of argument is one that's been adopted by the Trust and also by some of the interveners. We say, in fact, that the case should be made in the opposite way, and it should be made in terms of the gravity of the consequences. There's the case of Cream Holdings Limited and Banerjee is before the court, and I would ask the court to look at paragraph 22 on page 2325 in relation to this point. And this was, the House of Lords was considering the threshold test for making interim injunctions in the light of Section 12.3 of the Human Rights Act and what requirements were imposed there. But And they were looking, what does more likely than not mean? Is that got a fixed meaning? And when deciding whether to make an interim injunction. And House of Lords said that, went on to recognise that a lesser degree of likelihood will suffice where the adverse consequences of disclosure are particularly grave. So where someone's life's at risk, our submission would be that a lesser degree of likelihood should suffice for the court making an injunction. So if, and then we look at the case law, for example, in Re-Officer L, the risk there was, under Article 2, was, perhaps I could take the court to paragraph 20 of that case on 3094.
I think you'll find that that came under some criticism from Lord Hope in a subsequent decision. I can't remember which one it was, and is also inconsistent with Rabone as well. But anyway, be that as it may. The wording that Lord Carswell used, it is, in my opinion, clear that the criterion is and should be one that is readily satisfied. In other words, the threshold is high, was exactly what Lord Hope criticised subsequently.
But our point is, the point I'm making is not precisely what whether that's pitched the threshold correctly.
But I'm sorry for interrupting again. This is Article 2, intervention for the positive duty to protect life. And here you've got a balancing exercise in which you're postulating that there's a threshold for the risks to Article 8, but you're not postulating any threshold for the interference with Article 10. And it all comes out in the wash. As soon as you have a balancing exercise, you can see what the degree of risk is and how both of the rights are affected. And I have great difficulty at present in understanding why there should be a threshold rather than just a simple balancing exercise, as Lord Stein suggested. I don't see how you can read across an Article 2 threshold for a state having to expend a considerable amount of money on protecting people to a balancing exercise between Articles 8 and 10.
The point was simply this, and if there isn't a threshold, then the point doesn't go anywhere. But if there is to be a threshold, and one understands the concerns of the state, where it has an absolute obligation under Article 2, but relying on Cream Holdings Limited and Banerjee, we would say that where the consequences are serious, then a lesser degree of likelihood would suffice in order to make an interim injunction, and say that principle is a reasonable principle. If there's a risk that someone is going to be killed, then the court errs on the side of caution. And it's evident for that reason that where it comes to Article 2 or Article 3, and here is in the context of interim injunctions, that the court should err on the side of caution. Where the consequences are less grave, then the degree of likelihood may be pitched higher. But we're not asking for the degree to be pitched any higher. We're quite content for it to be pitched as it has been in these other cases of being a real and immediate risk of harm. I think that's the correct threshold, if a threshold has to be applied. I take Stevens's point. We say that considering Article 10 independently, there isn't a threshold because there's a clear interference with speech. Article 8 does require thresholds because it's potentially limitless in scope as an article. And you'd have the same problem that if you didn't apply thresholds to the engagement of Article 8, that you'd end up with the state having all sorts of obligations that would end up being a lot more burdensome than any obligations it could have under Article 2, positive obligations. So Article 8, which potentially encompasses all aspects of people's decision-making and relations with others, is subject to thresholds, we say. And so I just mention the cases of Perenchek and Switzerland. At 4061, I would have taken the court to 4145 and 4147 and 4148. These are cases about calls to violence and passages about calls to violence and hate speech. And where an interference with Article 10 rights is justified, what threshold has to be met there. Yefimov and Russia, which is at 4296, and the key paragraph is 4307, where the court considers evidential thresholds required to satisfy the pressing social need test. And finally, Dilipak in Turkey, which is at 3833, and it's paragraphs 60 to 64, at 3844 to 3845, which, again, we would look at. But these relate to the disorder limb of the concerns that the President had. I say that at the outset. But what they do show is that the threshold there is high. But we're not talking about people making adverse comments about someone on the internet. This is serious disorder which is existing, and which is the risk of that disorder, in order to justify an Article 10 interference, has to be high, and it has to be serious, quite apart from any balancing. And again, the point being that the court is making an injunction to restrict speech, partly on the basis that it approached the President, partly on the basis of a risk of public disorder. And Strasbourg has consistently applied thresholds. My Lords, on the compelling evidence requirement, I refer the court to our written case, where we mention 5 reasons which are drawn from paragraphs 119 and 77 of the Court of Appeal's judgment. But it's all set out in the written case as to why it's appropriate in the circumstances for there to be a compelling evidence requirement. And the first reason is because the case involves a derogation from open justice. And it's the reason is as simple as that. It's not simply an Article 10 versus Article 8 case. It's a case which involves derogations from open justice, and those do require compelling evidence, and the case law is very clear on that. And the passage from Lord Steyn, where he says that the court has no power, whether we understand that to be judicative or constitutive power, to create by process of analogy, except in the most compelling circumstances, further exceptions to the general principle of open justice, is really all that needs to be said. There was concern expressed that the Court of Appeal was looking at the use of the word compelling in different circumstances, whether it's compelling evidence or compelling reasons. But in fact, I would say that criticism is unfair, because the point's the same, whether one talks about the need for compelling reasons or the need for compelling evidence. In Wolverhampton, as my Lord Reid pointed out, one of the necessities before the injunctions are made is the compelling need. But it's They're in a different context, but in this context of an open justice restriction, that's the point that was being focused on in the various cases where that term was used. And if I could take the court to Sir James Mundy's remarks in A and Award, 3054, paragraph 24. He says there, what I referred to as a class claim, that is a claim that any professional who falls into a certain class, and in the case of social workers, the membership of the class is very large indeed, is for that reason, truth be told, for that reason alone entitled in current circumstances to have their identity protected, in plain language, to have their identity concealed from the public, will not succeed. Anonymity should not be extended to experts, local authorities and social workers unless there are compelling reasons. And this was the case of Reed J, in which he was citing Reward when he made that claim before, but he then adds that final paragraph, will not succeed. Anonymity should not be extended to experts, local authorities and social workers unless there are compelling reasons. And that's not, we respectfully submit, that's not simply an observation about the state of the evidence that was before the court, though there wasn't any particularly strong evidence. This principle is being laid out there, which is entirely in conformity with the other decisions.
But if all the members of a particular group are exposed to the same Article 8 risk, I mean, what's the objection of saying this is a group, they face the same risk, and asking the court to protect them uniformly against that risk?
The objection goes to Article 8 protects individual autonomy. It's not about classing everyone as a group and assuming they all have the same desires. They don't. Some people, and we saw that when we looked at the survey question, some people want to have open justice. Some clinicians want to be identified and think it's important that they should be in these cases. Others maybe don't, but then if they're not, if they do wish for anonymity, it's still, the threshold requirements need to be met. And there are two threshold requirements. One, which are in my written case, it's well-known law, but we didn't go into it, but relate, there's an objective harm threshold, which could be applied to everyone, because that's an objective test. But there's also a subjective detriment threshold. So someone may say, look, yeah, okay, I'm going to be attacked on Twitter. I don't care. And that person, their Article 8 rights are not engaged at all. So that's the issue.
But going back to the debate we had before about the speed with which these things might happen, if, because of the speed, it's not possible to go around all the clinicians taking instructions from each and every one of them, is it objectionable for some form of representative application to be made, provided that there are safeguards to allow those who don't want to be protected afterwards to come forward and say, no, betcha, I don't mind?
So there are two elements to that. One relates to treating clinicians, and one relates to witnesses, and rather different concerns apply. If a witness is to be covered by, and there's some overlapping of the categories because some of the treating clinicians then act as witnesses, but if a witness is to seek protection, then different principles do apply, and it may not be appropriate to make that sort of to make that sort of order in their case, and the reason for that is contained in Kuja at 3523, which at 34.3, where Lord Sumption states that a party is entitled to invoke the right of privacy to protect his reputation, but, as I've explained, there is no reasonable expectation of privacy in relation to proceedings in open court. So if someone is relying on a convention justification for an interference with their for the imposition of an injunction, then they're not going to be able very readily to satisfy, to show that they had a reasonable expectation of privacy in relation to evidence that they gave in open court. And that's the problem. In the case of a clinician, if there's who's giving evidence in court, if an injunction's to be made, it's going to be difficult to justify it, at least on the state of the law as it is now, on the basis of an in res balancing exercise. And that's why we say in those circumstances it may be that the court would rely on powers under the inherent jurisdiction in order for the promotion of justice. If that witness said, I will not testify unless I'm anonymized, then the question isn't whether an in res balancing exercise is performed, it's whether the court, under its inherent powers, is able to control how evidence is deployed in court and whether there is anonymity or not. But the limits to that is, first of all, there's a necessity threshold there, and that's established in law. It's not that the court could just make an order and say, well, the witness won't testify, so there's anonymities granted. They're going to have to be sure that concern is reasonable, and that also that witness really is needed, because if the evidence could be supplied from someone else, then that necessity threshold is not made. And then beyond that, it's not clear how far after the proceedings are ended it's necessary in any case for jurisdiction under that inherent jurisdiction to last for. And probably the answer is very different to, it may well be that the answer is, well, even if that case is made out, it's only during the currency of the proceedings. Whereas with the concern of people who were not witnesses, a 28-day limit, say, may be more easy to satisfy. So it's just providing that two different categories of people are recalled with different thresholds that apply, then it may well be that approach is appropriate. Our concerns remain, but I appreciate that on jurisdiction and the others that we've laid out, but I appreciate that the court may be seeking to find a solution. We say the solution lies at Parliament's door. It's not for this court to make new categories of exceptions to the open justice principle. But I appreciate the court may feel that it does need to do this. And quick point, but this is an important one, about compelling evidence. Had a clinician been seeking, for argument's sake, a restriction against the specified disgruntled patient who had made threats against that clinician, and wanted an injunction to prevent that patient from publishing private details, say, of the clinician's home address. In that circumstances, the court would be asked to perform a balancing exercise. An application has properly been made under misuse of private information tort, and the court is doing a balancing exercise, and no one would claim in those circumstances there's a need for compelling evidence. But it's the nature of the restrictions which are sought also gives rise to the need for compelling evidence, we say. And where you've got restrictions sought against the world involving dozens of unnamed clinicians, and prohibitions which prohibit the publishing of information which is neither private, confidential, nor unlawful, then it is correct in our submission for the court to demand compelling justification, evidence, or reasons why such an order may be made. So it really does matter what's being asked for. And what's being asked for we submit, is quite extraordinary here. And it's for that reason that there really do need to be compelling circumstances. And the Court of Appeal was right to demand them. And finally, I note, as the Court of Appeal did as well, that in the Haastrup case, there was an acknowledgement and indeed a payment in medical negligence for the injuries which eventually led to Abbasi's death. And in those circumstances, that also would require very compelling reasons why the father should be allowed to discuss matters. In fact, as the injunction is framed at the moment, no one's even allowed to ask the father who the clinicians responsible were. So,
could I just ask a bit more about that? I mean, we haven't yet looked at the evidence in detail. That's something that we will do after the hearing. I don't know the background. Is it one of being negligence for which obstetricians were responsible, for example?
Essentially, but it all took place in the same hospital, and there was some overlap with the clinicians.
I see. Okay.
But everyone's covered, possibly with the exception, possibly of, just because of the way it's phrased, of the nurses involved in the original. In the obstetrics.
So no distinctions drawn between the end-of-life treatment and the earlier treatment in the course of which there was negligence.
There isn't, my lord. I would take the court to the injunction, but I'm just conscious that there's very
little time. Yes, I see. In fact, Lord Hodges helpfully passed me the order. I see it, and it covers the staff involved in antenatal care, labour, delivery, and then treatment since birth. So it's completely comprehensive.
Yes. My lord, I have little time. Just want to say a few words about the open justice ground. We have covered some of this already, but one authority we haven't looked at is an important passage from the case of Crown and the Legal Aid Board ex parte Came Todner, which is endorsed by the House of Lords, or cited by the House of Lords in Ries, and also by the Supreme Court in Cuja. But the passage can be found at 3216. And this is relating to the importance of a public hearing. And the court there says, this is the reason, paragraphs 4 to 5, but starting about halfway through paragraph 4, saying this is the reason it is so important not to forget why proceedings are required to be subjected to the full glare of a public hearing. It is necessary because the public nature of proceedings deters inappropriate behaviour on the part of the court. It also maintains the public's confidence in the administration of justice. It enables the public to know that justice is being administered impartially. It can result in evidence becoming available, which would not become available if the proceedings were conducted behind closed doors. And this is the important point, or with one or more of the parties or witnesses' identity concealed. It makes uninformed and inaccurate about the proceedings less likely. Any interference with the public nature of court proceedings is therefore to be avoided unless justice requires it. However, Parliament has recognised there are situations where interference is necessary. Lords, I've come, I think, to the end of my time and haven't been able to conclude on the sort of approach that we say would be suitable to adopt. But what I did want to say, just very, very, very briefly, is relates to the question of the necessity for these orders, because the courts have commenced on the assumption that there is a necessity for these orders, and reference has been made to the Charlie Gard case and the Alfie Evans case, and we've seen evidence and newspaper headlines about that. But there have been cases, especially after the Court of Appeal decision in this case, where reporting restrictions in very controversial cases have been removed after a number of weeks of the cases concluding. And cases which, in some respects, one might think were more controversial and received stronger press comment and criticisms levelled against clinicians than we've seen, certainly in say the Haastrup case. And there have been no reports in any of these cases of any harm being done to anyone. There simply hasn't been. There hasn't been any harm in the Haastrup case, as the Court of Appeal noted. Two of the expert witnesses were named. There's no evidence that they were subject to any harassment. In the Abbasi case, originally the order covered all the treating staff, but then it was reduced just to 4. There's no evidence that we're aware of that any of them have been targeted for any sort of vilification or abuse. And we have these other cases, which are also very controversial cases, which are mentioned by the interveners, where the reporting restrictions have expired. And there's been no suggestion that any of the staff have been subject to any adverse effects. So we would question the premise upon which the need for these orders is made. And we'd say one of the safeguards, and with this I conclude, that the court would need to insist on is that there is evidence that would necessitate any infringement of open justice, but also of Parents' Article 10 rights, if they're to be made, and evidence beyond the sort of speculative concerns which we say were adduced in this case. Unless I can assist the court further.
Thank you very much, Mr. Quintavalli. Mr. Miller.
Lords, I'll reply first of all on the jurisdiction arguments. In essence, 4 arguments were raised. I'll deal with each in turn. The first one was that from the outset, the parens patriae jurisdiction of the family division does not allow it to make contra mundum injunctions, that is, injunctions against the world. In bald terms, that's plainly wrong. As was explained in Re S, the family division always has the power to make reporting restriction orders to protect, for example, a child or a family facing harmful publicity. There's a long history of that in parens patriae cases, and there's a statutory basis for this power now under Section 37. What the respondents really seem to be saying, as we understand it, is that the use of those powers under Section 37 is constrained by principle and precedent. That's not contentious. And further, that it's wrong in principle for the power to be used to make and continue such an injunction where you're not protecting the child or the family or the administration of justice, but rather to protect the human rights of persons involved in or affected by the proceedings. But here our case comes into stark conflict with theirs. We say what is important here is the positive obligation to protect the privacy of the clinicians. That's the principal basis for the injunction, CRE, BBC and GNML, and that combined with the statutory basis of the power under Section 37 it gives rise to the jurisdiction. The point arose in the course of this discussion on the first argument, which Lord Sales raised, about whether Strasbourg would accept an Article 8 application from clinicians where they didn't make an individual application to the court. The answer to that, we say, is of course they would do, because Strasbourg would look at the substance of the human rights issue rather than the domestic form of the procedure. So they would assess whether the reasoning was correct substantively. And as we've said, the domestic courts accept that rights can be looked at this way, where the individual rights holder, Article 8 rights holder, is not necessarily a party or a claimant. So that's Greencorns and Riem, Leave and J and Riem. There is a further authority, and I did mention this to my learned friend. We've sent it through to the registry. It may be of significance on this point. It's called W. A Child, 2016 EWCA Civ 1140. And it was a slightly unusual case where, at first instance in a family case, social workers who had supported a father's allegations of sexual abuse were heavily criticised in a judgment by the trial judge. They were not parties to the family law proceedings below, but they were witnesses before the judge. And they appealed to the Court of Appeal in their own names, asserting their Article 8 rights on the basis that the first instance judge had infringed those rights, both in the way the findings were made during the trial, that they weren't given a fair opportunity to deal with the allegations and the criticisms that came out in the judgment, and also in relation to the fact that the criticisms were published in the way they were in the judgment. And the Court of Appeal accepted that they were victims of an Article 8 violation for Section 7 purposes, and on my Lord Reed's point, said under Section 7.1b they could raise the issue of their Article 8 rights in those self-same proceedings, even though they weren't parties, on appeal, and that they were victims because their Article 8 rights were breached in that way. And I've only briefly looked at the authority, but I think paragraph 118 is where the court says, look, the findings of the first instance judge were a judicial act. Whatever else they were an act of a public authority.
Yes, there's been at least one case where a complaint of this kind was made to the Strasbourg court, and the Strasbourg court found that the state had breached Article 8 because the judge had criticised the witnesses without giving them a fair opportunity to address the criticism.
But it could be any act or inaction of the judge as a public authority that engages articles, that breaches articles.
We have that now in our bundle as a separate.
I'm grateful.
Can I just ask, as you appreciate, it's very unusual for us to have a new authority in a reply. Mr. Quintavalle, does this case cause you any difficulty, or being referred to it?
Just having a look at it now, but I'm having a bit of difficulty absorbing everything quickly.
Yes.
I was going to say, and I did mention this to my learned friend before, I didn't want to be unfair. Before we started this afternoon, I said we'd sent it in because the point had been raised.
Yes, of course.
If he wants to put a note in afterwards, we have absolutely.
Yes, we'll give you that opportunity, Mr. Quintavalle. If anything arises from this case that you feel you need to reply to, then let us have a note within 7 days.
Grateful.
The second argument was that there's no jurisdiction to make injunctions at the request of the trusts, who have no Article 8 rights themselves, in order to protect the privacy interests of third parties. And it seemed to us there were really three different points here. The first was the position of the trusts. Well, the pre-Human Rights Act public law case of Broadmoor was relied on. But the obvious answer to that is that wasn't an HRA case, so it's not relevant to the argument that we're advancing. But the position of the trusts here anyway is different to Broadmoor, completely different. Happenstance has them as parties to the end-of-life proceedings because they instigated them. But they were not making a claim for injunctive relief in the High Court in the way Broadmoor was in that case. It's true that they opposed the parents' application to discharge in 2021 on the basis of their concerns about the Article 8 rights of the clinicians continuing to be protected. But the key point is, once you've got to that point, as we've discussed before, the question of the court's obligation takes over. It has to decide for itself, are these Article 8 rights engaged? If they are, might there be a breach of Section 6.1 if the court does not act to protect them? And then it says, well, if we do act to protect them, it'll infringe the Article 10 rights of others, so we have to do a balancing exercise. That's the court deciding to act or not act, as I've put it. And that's completely different to Broadmoor. The second argument was that the Article 8 rights of the clinicians were not engaged in the absence of evidence about them individually. I don't want to get into the latter point because we've done it to death in a way, but it is contentious and disingenuous. We didn't know who they wanted evidence from. We asked but didn't get an indication. So we couldn't really do that. But more importantly, and this is important, and I do want to make this point because it cropped up repeatedly in the Learned Friends submission, the engagement of the Article 8 rights was never an issue in this case, either before the President or the Court of Appeal. Both proceeded straight to the second stage of the balancing exercise. I took you to the evidence of the two medical directors yesterday, and it was on that basis, as I understand it, the President and everybody accepted that the rights were at least engaged. The third argument is the odd argument, as we understand it, that the injunctions against the world as a side wind may prevent some clinicians speaking publicly about the case, identifying themselves, but they're not parties to the proceedings individually. And the point seems to be that if their rights are adversely affected, they must be put on notice of the proceedings by service. This is the Cameron point. But even if it's correct that their rights are adversely affected, and they had no notice of this at the time, which seems unlikely given the Trust's evidence, they're no different, are they, to anybody else in the world who is affected by a contra mundum injunction. Their rights are necessarily curtailed. They're not notified parties, but they would be in contempt on the spycatcher principle if they knew about the injunction and breached it. But it seems to us that in the human rights injunction cases referred to in Wolverhampton, and these sorts of cases, at least in the immediate period after the injunction, this consequence is regarded as acceptable for the protection that's given to the group generally under Article 8. And as we've discussed, an application can be made to release them from the injunction if that's required. But at that point, the only effective remedy is a broader injunction. The third point was Article 6 and the suggestion it doesn't permit a derogation from open justice for the benefit of non-parties. And we're back here, I'm afraid, to the question of whether the continuation of these orders was ever argued as a derogation from open justice. And the fact is, it wasn't. It wasn't in the Abbasi case at all. It was as a fallback submission by my learned friend in the Haastrup case, who said, well, if all else fails, I'm repeating myself here, those few clinicians who gave evidence of fact should be de-anonymised. But as you say in the case, if that's what the argument had solely been about, it would have been a very different case before the President would have looked at Tyne and all those authorities and argued the case 2 years on for de-anonymising those clinicians. On the Lord Roger basis, would it materially benefit a discussion of public interest, being the court reporting of the Haastrup best interest case, to have their names now in the public domain? But it simply wasn't what we were arguing. Even if this is seen as an order derogating from open justice, which it isn't, the Article 6 point is a non-point. The Article 6 right is a right given to a party, as we've discussed, whose civil and criminal rights are being determined by a court. It's a human right. It doesn't determine the jurisdiction of the domestic court to derogate from open justice. Of course, if the parents had the right, they could have and can at any stage assert it and say, this is an extra reason why you shouldn't engage in this particular derogation. And they could even try and argue that if the derogation materialises, it's a violation of their Article 6 right. But That's a different thing to jurisdiction. That's nothing to do with jurisdiction. And I would also add, for good measure, as a bald proposition, again, it's also wrong. And my Lord Reid, in his judgment in A versus BBC, I'll just give you the reference, paragraph 44, 1797, referred to the well-known case of Dawson versus the Netherlands, which was a criminal case. It was an informant case involving drug dealing in the Netherlands, where the criminal court had anonymised informants, and the defendant was complaining about a violation of their Article 6 rights. And the Strasbourg court had no difficulty at all in saying there wasn't a violation of the Article 6 right by anonymisation of the informant. I mean, the facts are everything, but that's the sort of argument that you get into. It's nothing to do with jurisdiction. Finally and fourthly, there's the point about the Article 10 interferences with free speech not being prescribed by law. Well, let's just focus on what the issue is here. In the UK, an interference with a human right can be prescribed by law, which is a convention concept, in the form of, and this is well established going back to the Sunday Times case, by a form of precise and accessible common law rules. So it's a series of cases that forms a precedential common law rule. And this is exactly what has happened with Venables, Ries, BBC, GNML. These cases give us common law rules that are precise and accessible. The point about it being not Parliament but the courts that are developing the law under the Human Rights Act comes up time and time again. Post-Campbell, of course, the courts have developed the misuse of private information tort beyond confidentiality to a distinct tort, and then in PGS, an invasion of privacy tort. This is how the common law works. It is not objectionable. Parliament gives the underlying powers and statute, and the courts do that. There are many cases where that happens. Just on the second part of the case, the Court of Appeals misdirections, just a few points, no more than 5 minutes. First of all, my learned friend said in his submissions, at one point, or suggested that the issue of veracity or truth didn't arise because what the parents were this may have been a slip of the tongue, what the parents were going to say was our child was treated by these clinicians, and that is true. But it's quite obvious from the judgment for the President and from our point of view, that's not what the problem was. It wasn't just them saying that. It was them saying that in conjunction with serious allegations of professional misconduct and wrongdoing. And that's what the truth of that needed to be tested. On the generic evidence point, the other side went to paragraph 113 in the President's judgment at page 346. It's the bit, it's the part where he says, probably don't need to look at it, he says, and in a vertical case, you can look at the methodology of legitimate aim and justification, so why can't you look at it in a balancing exercise case? And my learned friend criticised that, and indeed us, but he may have understood us and the President and what we take the President to be saying. And we touched on this yesterday in submissions and in an exchange with Lord Hodge. It's not that those things aren't there in Article 10.2 or Article 8.2 or are irrelevant. The way I would put it is that the methodology of Article 10.2 and Article 8.2, legitimate aims, justification, become absorbed into the parallel analysis because they're both rights of equal value and they're sitting alongside each other and they have to be weighed against each other. So it's just, if I can put it this way, they're not as visible as they are in a vertical interference case. They are there, but they merge because the premise for the exercise is that both convention rights are engaged. They're both there to be balanced. So that's the starting point.
But surely the court has to go through in a properly rigorous way the analysis under Article 8 and then the analysis under Article 10. They're not going to be the same analysis.
Oh no, they're not going to be the same analysis, but they run alongside each other. So this is, Lord Steyn doesn't say that in paragraph 17 in Re-S, but that's implicitly what he's saying. That's the point of the parallel analysis. You do it as if in each case it's a vertical application case, but it isn't a vertical application case. But the primary justification is the engagement of the other right and the conflict of the two rights.
Right, but I mean, if Lord Steyn is saying you do each of them as a vertical application case, then it might be said that there is a problem with what the President says in paragraph 113, because he says it's not like that.
Yes, I can see that, but I'm just not sure that's what he's saying. He may have expressed himself wrongly, but I think he was saying it's just not visibly done in the same way in a balancing case.
Well, it should be astonishing if you were balancing Article 10 on the one side and Article 8 on the other side, and you didn't have regard, respectively, to 10.2 and 8.2 as they go into the balance. So the point may be in your favour in the sense that that may bring in, 10.2 may bring in certain public interests that 8, the balance with 8 would not.
Yes.
As Lord Sales says, you must look at each right and its limitations in the round as they go into the balance.
Yeah, I mean, in a sense, that's a point for you in terms of the vertical analysis, in terms of the range of public interest, legitimate aims that can be brought into account.
Yes.
But speaking for myself, it seemed a little bit problematic for you, on the other hand, just in terms of trying to defend paragraph 113 of what the President said.
Maybe it's badly expressed, I don't know. But I mean, one issue that's often raised with the parallel analysis, having been in Re-S and having partly been responsible for it, is that it is a difficult exercise, and for a judge to articulate the process on both sides fully and completely in the way you would in a vertical analysis is quite a difficult thing to do. But we say the President did a good job of it in this case. The ZXC was referred to, and I just wanted to make this point about ZXC. I don't want to repeat what I said earlier about it, but the key point in ZXC that one needs to understand is that the claimant ZXC did not have the right of confidentiality that the law enforcement agency was asserting. The claimant had an Article 8 right to privacy. The confidential information was the confidential information of the law enforcement agency, which the media got hold of and published. And so when my learned friend was addressing that, he tried to suggest that in those passages we looked at, where this court talked about the public interest or societal interest in protecting confidentiality generally in letters of request cases, that was something to do with the Article 8 rights of the claimant. Well, it wasn't. That's the whole point. It was a completely separate consideration that arose because a law enforcement agency had confidentiality rights. The case of, on this question of generic evidence, can I just mention the H case, which my learned friend took you to? I won't take you to it. I'll give you the reference. Paragraph 27 at EF 2424. Ironically, my learned friend has cited the case, but it's also at that paragraph another very good example in a balancing case of the public interest being taken into account in support of an Article 8 injunction. What happened in that case was that a clinician was HIV positive, and there was a procedure for reporting back over their previous cases once they found out they were HIV positive. And there was a dispute about whether that could be written about by the press and whether he could be identified. And what the court said was the public interest generally in protecting that system for patients and for nurses and clinicians who are HIV positive is an additional reason for granting the Article 8 injunction in this case. So it's a very good example of that. But as we've said, the courts do this, it seems to us, regularly without objection. Vucinovic versus Moldova, well, we weren't relying on it for the facts. I apologise if we didn't make that clear. simply recognition that there are certain categories of public servants who require protection from unfounded attacks that undermine public confidence in them, and prosecutors and police are examples in the previous cases. I accept there's no Strasbourg case on that for doctors. What this court may have to consider is, well, are the clinicians in that sort of category in this case? And we say they are. Finally, Chascneau was cited versus France, 3709, paragraph 113, the hunting case. But that wasn't a balancing case. So where the court made those comments about non-convention rights of others, requiring extra force if they're going to be relied on in a vertical application case, that's a completely different thing, because in a balancing case, the primary right of others that is in the balance is the Article 8 right of the person who's asserting Article 8. So it's a completely different type of case. Anything else? Oh, yes, sorry. So those are my submissions in reply. Housekeeping, if I could, just finishing. Ms. Patterson has been very busy, as was my known friend overnight, so we didn't manage to agree all the written references that we were going to give my lord. But what we've got and what we will give you in the next 7 days is all the references in the bundle to the evidence that was before the first instance judges when the RROs were made. And so you can home in on that. There are skeleton arguments and things in the bundle. And secondly, references to service of those orders initially on the press, because Lord Stevens was concerned to see how the procedure worked for the Press Association and so on being told of them, and we will let you have those references. We want
and that will be agreed with Mr. Quintavar.
We want to agree with my learned friend, and we sent him some of the material overnight, but it seems unfair when he was preparing to require him to go through that. We'll do that in the next 7 days.
Thank you. Yes, Mr. Quintavar.
My lords, apologies to my learned friend if I misunderstood something he said, but if I didn't misunderstand, it's important I correct a matter of fact that was claimed, and that was that in the courts below, that we didn't run the argument that Article 8 was not engaged. In fact, that was our third ground of appeal before the Court of Appeal. I have my skeleton in front of me. The ground, as framed, was that the court wrongly balanced rights in the absence of any proof that Article 8 was engaged. And it was an argument that was addressed.
Thank you. Well, we're most grateful to all counsel for the assistance that you've given us. This is obviously a very important and difficult case. We'll have to take time to consider the arguments that we've heard. We'll let you have our judgment when we can. The court will adjourn.